My ex-wife walked into court smiling, certain she was about to win everything. She even brought a surprise she thought would change the judge's mind. I said nothing. Then the judge asked one question, and suddenly her lawyer stopped smiling. Subscribe to Vox Narrator right now, because this story is the one that proves preparation is the only weapon that never misses. I'm 31 years old and I'm sitting in my car outside a courthouse at 4:17 in the afternoon, and I've been sitting here for 40 minutes because I came outside after the hearing concluded and I sat down in the driver's seat and I haven't been able to make myself start the engine yet. Not because I'm upset, because I'm 31 years old and I just watched 18 months of careful, disciplined, unglamorous work produce a result in approximately 90 minutes that I'd been told by several people, including, at various points, my own attorney, might not be achievable, and the transition from 18 months of building towards something to 90 minutes of watching it land is a larger adjustment than I'd anticipated. The courthouse is a standard-issue county building, the kind with institutional lighting and dropped ceilings in the hallways and courtrooms that smell like old paper and the specific, low-grade anxiety of people at significant junctures in their lives. I've been in this building 7 times over the past 18 months. Today was the 8th, and, barring appeals that my attorney considers unlikely given today's outcome, the last. She walked in smiling. I want to start there because the smile is the beginning of the story, the thing that set the tone of the morning and against which everything else that followed can be understood. She came through the courtroom door with her attorney about 4 minutes before the session began, and she was smiling the specific smile of someone who has something prepared, who has a move they're confident in, who believes they know how the room is going to go. I've known that smile for 6 years. 3 years of marriage and 3 years of whatever the marriage became before and after it ended. It's a smile that's always been connected to confidence, and her confidence has always been real and sometimes been warranted and sometimes been the confident surface of someone who hasn't fully accounted for what the other person in the room knows. I was sitting at the respondent's table when she came in. My attorney was beside me, a woman I'd worked with for the full 18 months, someone I'd chosen specifically for her reputation, for methodical preparation and her specific lack of theatrics. I'd watched her across the table during depositions and preliminary hearings, and I'd understood early that she operated the way I operate, quietly, thoroughly, without announcing what she was building until the building was complete. I looked at the smile. I looked at the person beside my ex-wife, the surprise she'd brought, which I'd anticipated because my attorney had anticipated it and had told me 2 weeks ago that it was coming and had walked me through exactly what to do with it when it arrived, which was nothing. Just let it arrive. Let the room process it. Let the judge ask the question the judge would inevitably ask. Then I looked at my documents folder on the table in front of me, and I waited. Let me tell you about the marriage and the divorce and the 18 months of building, because the courtroom this morning is incomprehensible without all of that preceding it, and I want to give you the full picture, rather than the compressed version. We got married when I was 26. She was 28. It was, in its first 2 years, a real marriage in the meaningful sense, genuine connection, genuine building, the real attempt of two people who had chosen each other to construct something together. I'm not going to reduce the good years to backdrop because they weren't backdrop. They were real, and they mattered. And the fact that they ended badly doesn't retroactively unmake what they were. Year 3 is when the building stopped and a different kind of architecture began. I'm going to describe this carefully because the carefulness of the description is what makes it honest, rather than bitter. She had, by the 3rd year of our marriage, developed a relationship with money that was different from the one she'd had when we met, and different in a direction that created real and lasting friction. Not extravagance for its own sake, something more specific than that. Relationship with money as a form of security, as a buffer against a vulnerability she'd carried from before me and that our marriage, apparently, had not resolved. The relationship expressed itself as financial decision-making that was unilateral, that drew from our shared resources, without shared discussion, and that when raised as a concern was invariably reframed as my controlling nature or my inability to trust her judgment. I raised it 3 times across 18 months of year 3 and the beginning of year 4. Each time the conversation followed the same structure. I raised a specific financial decision I hadn't been part of. I explained why the exclusion concerned me. She reframed the concern as a character failing of mine. The conversation ended without resolution. By the third time, I had a clear understanding of the pattern and a clear understanding that the pattern was not going to change through conversation alone. The discovery that formalized the end of the marriage was financial. I'm going to describe it in the general terms my attorney advised rather than the specific ones, because the specific ones are still legally relevant and some of the details belong to processes that remain active. What I'll say is that I found, through the careful review of shared financial accounts that I undertook in the fourth year, evidence of a pattern of transactions that had been structured specifically to be difficult to notice in ordinary review. Not impossible to notice, difficult. The kind of structuring that requires intention and some understanding of how account monitoring works. I looked at it for a long time before I did anything with it. Then I made an appointment with a forensic accountant, a professional who does exactly this kind of work and who I found through a referral from a business contact. The appointment was 2 hours. The forensic accountant looked at what I'd assembled and told me what it was and what it meant and what the documentation process looked like if I intended to use it in a legal proceeding. I told my attorney 3 days later. She looked at the documents for a long time and then looked at me and said, "How long have you had this?" 3 weeks, I said. You waited 3 weeks before bringing it to me? I wanted to understand it completely before bringing it to anyone, I said. She looked at me for a moment and then said, "This changes things significantly." I said, "I know." The divorce filing happened 2 weeks later. I'm not going to detail the full 18 months of proceedings because they were long and grinding in the way that legal processes are long and grinding, and the details of intermediate hearings and procedural steps are less important than the two things I spent the 18 months building toward, which were the financial documentation and the preparation for whatever she was going to bring to the final hearing. My attorney had told me 8 months before the final hearing, she's going to bring something. People in her position, when they know the financial evidence is against them, look for something that reframes the character of the other party. You need to be ready for that. I asked what ready looked like. It looks like documentation, she said. Of everything. Your conduct, your communication, your financial contributions, your consistency. Anything she might use to characterize you negatively, you want the counter documentation already assembled. I spent the following 10 months assembling it, not in a paranoid way and in the methodical way of someone who has decided that preparation is the only reasonable response to uncertainty. I kept records of every communication. I kept records of every financial contribution to shared expenses. I kept records of every significant interaction that might later be characterized as other than what it was. I stored these records in a system that was organized, dated, and backed up in 3 separate locations because I'm the kind of person who backs things up. 2 weeks before the hearing, my attorney told me what she'd learned through the discovery process about what my ex-wife was planning to bring. I want to describe what it was in general terms. She had a witness, someone who was going to testify to a characterization of my behavior during the marriage that was, to put it precisely, inconsistent with the documented record I'd been building for 10 months. The characterization was designed to shift the court's view of the financial evidence, to suggest that the financial decisions I'd described as unilateral and problematic were actually reasonable responses to circumstances of my creation. My attorney told me this, and then told me not to worry about it. Why not? I said. Because of the question, she said. What question? The one the judge is going to ask when she brings the witness, she said. Judges in financial proceedings ask it when a character witness appears. It's procedural. And when the judge asks it in this case, the answer is going to do more damage to her position than anything we could introduce. She explained the question and the answer it would produce, and I sat with it for a long time. You knew this was coming, I said. I suspected it 3 months ago. I confirmed it 6 weeks ago through discovery. And you didn't tell me. I'm telling you now, she said. 2 weeks out. Early enough to prepare, late enough that you don't spend 3 months managing anxiety about something that's already handled. I thought about that. Then I said, that's very deliberate. Good preparation always is, she said. The morning of the hearing. I want to describe it with the precision it deserves. I arrived 20 minutes early. I sat at the respondent's table and I organized my folder and I reviewed the key documents one more time, not because I didn't know them, but because the review was a ritual of preparation, a confirmation that what I'd built was complete. She arrived 4 minutes before the session with her attorney and her witness. The witness was someone I recognized, a mutual acquaintance from our social circle, someone who'd been closer to her than to me, someone whose presence I'd anticipated based on what my attorney had told me. The smile she wore when she came through the door was the smile of someone who has looked at the board and counted pieces and believes the count favors them. The session opened with her attorney presenting the financial counter-argument, which I won't detail here because the counter-argument was answered by the documentation my forensic accountant had prepared and which my attorney introduced with the specific, unrushed efficiency of someone presenting information that speaks for itself. I watched the judge's face during this presentation, and I watched the quality of the judge's attention shift in the specific way. That attention shifts when information is landing rather than just being received. Then her attorney introduced the witness. My attorney made a procedural objection that I won't detail. The objection was partially sustained in a way that limited the scope of the testimony but didn't prevent it. The witness testified. The characterization was delivered in the practiced way of someone who has been coached on the delivery, which is different from the unpracticed way of someone who is telling their honest experience. And I watched the judge watching the delivery. When the testimony concluded, the judge looked at the witness over reading glasses with the specific quality of attention that judges develop over years of watching people tell versions of truth and asked the question. I'm not going to reproduce the question verbatim because the verbatim is legally specific in a way that could identify the parties, but the question was this in substance. It asked the witness to account for a specific documented event that was part of my record, an event that had occurred during the period the witness was testifying about, an event that directly contradicted the characterization the witness had just offered. The judge had the documentation. My attorney had introduced it as an exhibit 30 minutes earlier. The judge had read it while the witness was being sworn in. The witness paused, then began an answer that was the verbal equivalent of someone who has encountered an obstacle they weren't told would be there and is navigating it in real time. The answer was not dishonest exactly. It was incomplete in a way that was visible to everyone in the room who had the documentation in front of them, which was the judge, and both attorneys and me. Her attorney's face during this answer was the thing I'll carry longest from this morning. Not the testimony, not the judge's expression, not even the outcome, her attorney's face during her witness's answer, which was the face of someone watching a prepared argument develop a crack they didn't anticipate and understanding in real time what the crack was going to cost. The judge asked a follow-up question. The follow-up was worse for the witness than the first, because the follow-up was specific in a way that required either a direct contradiction of the documented record or an acknowledgement that the characterization had been incomplete. The witness chose a third option, which was a qualified answer that walked back enough of the testimony that what remained was insufficient to accomplish what it had been brought to accomplish. The session concluded 40 minutes after that. I'm not going to detail the judge's findings in full, because some of them are still being implemented and the implementation process has its own legal timeline. What I'll say is that the financial documentation was accepted, the characterization was not given the weight it had been intended to carry, and the outcome of the morning was significantly better for my position than the position I'd been in when I walked into the building. She was not smiling when the session concluded. Her attorney was talking to her in the low, efficient way of attorneys communicating necessary information immediately after proceedings, and her face had the specific stillness of someone who had arrived with a confident count and was being told the count was wrong. I didn't look at her longer than necessary. I thanked my attorney. I shook the hand of the forensic accountant who had come to be available for questions and whose questions had not been needed because the documentation had been sufficient. I walked out of the courtroom and through the institutional hallway that smells like old paper and into the parking lot where I've been sitting for 40 minutes. The 18 months were a forensic accountant's appointment, 10 months of organized documentation, careful record keeping, backing things up in 3 places, saying less in intermediate hearings than I wanted to say because my attorney told me that restraint was preparation, waiting for the question that I'd been told would come, and that came, and that did what it was predicted to do. That's what winning looks like when it's real, not dramatic, not loud, organized and patient and built over a very long time by a person who had decided that the only response to someone who underestimates you is to make the most of the time that underestimation buys. She underestimated me for 18 months. That was enough time. Now I need to hear from you. Have you ever built something over a long period that most people around you couldn't see taking shape? Have you ever sat in a room and watched someone's confidence fail at exactly the moment you'd known it would? Tell me below, because I think the people who've done the quiet work know what this morning felt like better than any description I can offer. Edit. The comments want to know about the witness, whether I was surprised by who it was, or whether I'd known in advance. I'd known for 6 weeks through the discovery process, as I mentioned. What I hadn't known, until my attorney told me 2 weeks before the hearing, was the specific angle the testimony was going to take. When I understood the angle, I understood why the documented event was relevant. Because the event was a direct, time-stamped, third-party verified contradiction of the characterization the testimony was going to offer. The documentation had been in my file for 8 months. I'd assembled it without knowing exactly which piece would become the most important one. That's why you document everything, not because you know which piece will matter, but because you don't know, and the piece that matters is rarely the one you predicted. Edit 2. Someone in the comments is asking whether I feel good about the outcome or whether it's bittersweet given that it's the end of a marriage that had real good years. Honestly, both. The outcome is the right one. The documented record is accurate and the process produced a result consistent with that accuracy, which is what legal processes are supposed to do. The bitterness is real too, not toward her specifically, but toward the situation, toward the version of the marriage I'd believed in and had built toward, and that turned out to have been built on a foundation that wasn't as solid as I'd thought. You can be glad about an outcome and still grieve. What had to happen to get there? I'm doing both. I'll probably be doing both for a while. If this story gave you something tonight, if you recognized something in the patience or the preparation or the moment the smile left the room, drop a comment below and tell me what it was. I'm here, I'm reading, and this thread is the most honest space I've had since I started building that folder 18 months ago.